I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are bringing you number 87 on our compilation list, and I must say I am blown away by one of the sovereign citizens that is making a special appearance on today because he is a former TV star that we've all grown to know and love, that know of the show Family Matters. Definitely was blown away and surprised by this appearance and by him going full sovereign citizen. But we have that on today in this compilation video for you. We're going to be in 3 different courtrooms on today. Before I give you the rundown on those judges, don't forget to like, comment, share, subscribe. Definitely give your comments and your thoughts on this particular individual going full sovereign citizen. But listen, let me go ahead and give you the rundown on these courtrooms. First, we will be in the courtroom of San Diego Superior Court. Second, we will be in the courtroom of Judge Freeing out of the state of Washington. And last but not least, we will be in the courtroom of Judge Atkins, also out of the state of Washington. Listen, nothing else to be said, guys, but let's go ahead and jump into number 87.
Mr. McCrary, did you have any objections, sir, to the media request? You indicated that you did. Did you have an objection? And the court indicated that its tentative was to grant the request for media coverage. Did you wish to put that on the record or no?
Yes, I mean, I'd like to put it on the record, only because I have other children than my 18-year-old son, which this matter is involving.
Okay, but only as it relates to the media request.
Oh, I just wanted to make sure that my other children weren't in the media if I mention their names or if it comes up in if it comes up in the proceedings.
Okay, thank you. And so the court finds good cause to grant the media coverage. The media coverage was granted as relates to ABC 10 News, and the court authorizes the sharing of media news feeds with other media outlets. So that is authorized. Upon further review of this case, the court finds that Mr. McCrary was before the court on October 7th, 2025. At that point, his request for self-representation was granted. However, the court finds that his acknowledgement of advice of rights regarding extradition was not signed. Sir, prior to representing yourself, were you advised of your rights regarding extradition?
All I know is that I was supposed to be on a 72-hour hold, and
Sir, my question to you is, were you advised of your rights regarding extradition?
No, Your Honor, I was not.
The court advises you as follows. The defendant in this matter has been advised of the following rights. The right to require the issuance and service of a warrant of extradition by the governor of the state of California before he can return to the state demanding his extradition. The right to have a qualified lawyer represent him in the proceedings in this state at all stages of the proceedings, and that said attorney may be the defendant's own choosing or shall be court appointed if the defendant is unable to afford counsel. When a warrant is issued by the governor of the state of California and served on the defendant has the right to test the legality of such warrant by a writ of habeas corpus and has the right to a reasonable time after the service of said warrant in which to apply for the writ of habeas corpus. The court finds that the defendant has been advised of his rights regarding extradition on the record in open court on October 15th, 2025. As relates to the complaint, sir, are you prepared to go forward with your arraignment?
Yes, Your Honor.
Please do so.
I wanted to call attention to the emergency motion that I filed. Based on the fact that, the 50th District has completely continued to violate all of my rights, my 4th, my 5th, my 14th Amendment, my right to due process is constantly trampled. And I've figured out why, because under due process clause of the 14th Amendment, personal judgment is void if rendered by the court, which has no jurisdiction over the defendant. That's Penmore versus Neff, 95 US 714 24L ED 565, and Michigan has no jurisdiction. Before we proceed, we need to establish jurisdiction. It's imperative that we establish jurisdiction.
People?
Your Honor, the people would argue that this motion is not relevant to the proceedings before the court, that it is now time to either admit guilt or not guilt as to the fugitive complaint that the people have filed.
Okay, thank you. Sir, did you care to respond before the court rules on your motion?
There's no injured party, Your Honor. Oh, I'd like to also say I'm here in special appearance.
Specially appearing for who?
I'm here on special appearance.
Sir, who are you specially appearing for?
I'm specially appearing for Darius McCrary. I'm here pro per special appearance.
And when you say you were here pro per and special appearance, who are you?
I'm an authorized signatory thereof of the estate and the executor of the estate.
Who's the state?
The McCrary estate.
And your name is?
I'm Darius. I'm the authorized signatory thereof, Darius McCrary.
And your name is?
Darius McCrary.
Okay, thank you. Anything else as it relates to your motion?
I would also like to add that that there's been as far as corpus delicti is concerned, I wanted to know who's the injured party.
The court finds that the issue before this court is the issue of extradition. This court is not the demanding state where many of these issues raised by the defendant may be relevant. This court is tasked with ensuring that the defendant is returned to the demanding state. That will happen either one or two ways. He will waive extradition or he will plead not guilty to the complaint regarding extradition, at which time a governor's warrant will be provided to the court at a later date. Those are the things that this court is tasked with deciding at this point in time. If you have any issues regarding the charges pending against you in the demanding state, then you may raise those in the demanding state. The thing before the court today is the extradition and the extradition only. As it relates to the extradition, is there anything else?
Well, Your Honor, is it possible that we could discuss a bail?
Bail arguments are heard after the entering of a plea has taken place. Again, as it relates to the extradition, are you prepared to proceed?
Yes, Your Honor.
Please do.
Meaning?
You're here for an arraignment. You were granted the right to represent yourself. When you made that request, you indicated that you would have the ability, the knowledge, the education to represent yourself in these proceedings. That request was granted. You were advised that you would not receive any special treatment as a pro se litigant, that you would be treated the same as an attorney. You are here for an arraignment on the complaint. Please arraign yourself.
Well, I'm asking, can we discuss bail, Your Honor?
And I have told you that the discussion of bail arguments are conducted after the entering of the plea.
Okay, Your Honor. So I guess I'm playing. What is it? No. I really.
Do you understand the legal proceedings pending before you?
I do, Your Honor. I do, but I wasn't.
So then please proceed with the arraignment.
So I wasn't here. I wasn't aware that we were here to contract today.
Okay, thank you. The court has attempted to conduct the arraignment with Mr. McCrary, and it is evident to the court that he is unable to understand and appreciate the legalities of these proceedings. As such, the court finds good cause to revoke his pro per status. The court appoints the office of the primary public defender's office to represent him. This matter is trailed.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Your Honor, calling number 105, Turner versus custody taken. Custody take lead.
Good morning, Your Honor. Vanessa Duval, Deputy District Attorney for the People.
Julie Gibson, Office of the Public Defender, on behalf of Mr. Darius McCrary, who is present in custody. Your Honor, we are here for arraignment on the complaint. He's been advised of his constitutional rights, previously signed the acknowledgement. We are entering pleas of not guilty, denial to any and all allegations, asking for appointment of the primary public defender's office, and would like to be heard with regard to his custodial status.
Okay, thank you. Thank you, and just for the record, the defendant did not sign the advisor of rights regarding extradition. Previously, the court went over those advisors with him in open court today on the record.
Thank you.
The court appoints the office of the primary public defender's office to represent him. Mr. McCrary's true name and date of birth appear on the fugitive complaint. He was advised of his rights regarding extradition. He waives further reading of the charges. The court enters his not guilty pleas to the charges and his denial of the allegations. The court has appointed the primary public defender's office to represent him. As relates to dates, the court will set this matter in 30 days for the governor's warrant, and that date is?
That date would be November 14, 2025 at 8:30, Department 101.
All right, thank you. As it relates to bail, the either counsel wish to be heard.
Yes, Your Honor.
Yes, Your Honor.
Please proceed, Ms. Gibson.
My argument has, I would ask that Ms. Duval be heard first. My understanding is she's going to make argument, and I don't have all the facts as to why it should be no bail, and I would ask for her to make those arguments first.
Okay, thank you. Ms. Duval?
Yes, Your Honor. The fugitive is before the court today for absconding or forfeiting bond on a non-payment of child support case out of Michigan. Clearly, Mr. McCrary is not attending to his family matters. He has 2 daughters and 1 son, and this matter is regarding 1 daughter who lives in Michigan. He has previously been ordered to pay child support. As of August 20th of last year, he owed $75,473.26. He owes substantially more at this time. However, Michigan could not give me a figure due to privacy reasons. The defendant has been arrested twice in the past on these same charges, in 2015 and 2023. In 2004, he's been arrested for disturbing the peace. Back in 2023, the fugitive had to be extradited from Los Angeles for these very same charges. The defendant was arrested coming back from Mexico. According to his agent, he was looking at buying real estate down there. He lists his current address as Woodland Hills, which is not in the county of San Diego, but in the county of Los Angeles. He has no ties to San Diego or Michigan. When he left Michigan, he actually had what they describe as a TETR, which is electronic monitoring, when he left the state of Michigan. For all those reasons, the people would argue that he is a flight risk. He's failed to take care of his obligations back in Michigan. We'd be asking for no bail in this matter.
Thank you. Ms. Gibson?
Your Honor, we are asking the court to set bail in the amount of $50,000, an amount for which he can afford. He made multiple court appearances on this case. There was the last time that apparently there was a notifying letter that was sent. They sent it, the district attorney's office in that state had both his email address, his phone number, as well as his counsel's email address, and they chose to send a notifying letter to a P.O. box that was not monitored by him often. And so with regard to the issue of coming across the border, he was across the border working with a group to build homes in Tijuana. There was nothing nefarious about what he was doing. We're asking the court, again, since there are no failures to appear that he has other than that demanding state, we're asking the court to set bail in the amount of $50,000, an amount for which he can afford, and he will make his court appearances. I've already talked to people that are here on his behalf, that are part of his team and represent that he will be returning to the demanding state. He is ill right now, and so I apologize to the court that it's taken a while to have the conversation, but he is adamant. He is a renowned figure. Everyone knows, that's why there are media here on his behalf, that he's going to appear in court. And I understand what the district attorney is saying with regard to prior incidents, but if they wanted him to appear in court, they had multiple ways to get him, and he did not know of the appearance date. So we're asking the court not to release him on OR, but to set bail in a reasonable amount that is $50,000 for him to make his court appearances.
Okay, thank you. Both counsel submit?
Yes, Your Honor.
Yes, Your Honor.
Thank you. The court has considered the arguments of both counsel here today, and the court finds as follows. The court finds that the defendant has previously been extradited, that he was arrested coming back from another country. It has been represented to the court that he has no ties with the demanding state, and most notably that he was on bond previously and absconded. Based upon those factors and findings, the court finds that the defendant is a flight risk, denies his request to set bail. He'll continue to be held without bail.
Your Honor,
and that is the order of the court.
I apologize. Thank you, Your Honor. At this time, after having previous discussions with Mr. McCrary, he is prepared to admit identity, I think he has, and to waive extradition.
He has not admitted identity.
Your Honor, he does admit identity, and he is asking the court to allow him to sign the extradition paperwork, and so we're getting some now. I did not have them. I'm not sure where they are from before, but that is our request to the court.
Okay, thank you. Sir, are you Mr. Darius McCrary?
Yeah, I'm Darius McCrary, yeah.
Okay, thank you. The court confirms the identity of Mr. McCrary as he's identified himself as Darius McCrary.
Yes.
Can we also get an audit?
Hold on.
You sure?
Your Honor, I apologize. It's going to take me a moment to complete these. How would the court like to proceed? Does the court mind waiting while I fill out these forms? They're blank.
Court's in a brief recess.
Thank you, Your Honor. Sir, I don't know what an audit is.
Ms. Gibson, you prepared to proceed?
Yes, Your Honor.
Okay, thank you. We're back on the record. The court is in receipt of the signed acknowledgement of advisement of rights regarding extradition signed by the defendant. The court is in receipt of a signed waiver of extradition to the state of Michigan signed by the defendant, and the court finds a valid waiver of extradition to the state of Michigan, signs the waiver of extradition. As such, this defendant is remanded to the custody of the sheriff without bail, and the court sets a 30-day date review hearing in this date, and that date is
November 14, 2025 at 8:30, Department 101.
okay, thank you. People, Given that the defendant has waived extradition, what is your request as it relates to the fugitive complaint?
People move to dismiss it, Your Honor.
That matter is, that request is granted. That matter is dismissed. Thank you both.
Thank you, Your Honor.
The court do a medical referral. He is quite sick.
The court grants the request and authorizes a medical referral for the defendant. That concludes this matter. Thank you both.
Thank you, Your
You're
Honor.
welcome. Thank you, Your Honor.
Thank you.
Your Honor, that concludes the morning's calendar.
Thank you. Court is in recess.
Three A 03123119 on for review, and 3A065525 on for review, and then on for arraignment is 4A04725552, 3A08209191, 4A023188, and 3A05 49215. And proceeding with the arraignment is your true and correct name, Sylvester Larnell Evans.
Sylvester Larnell Evans Jr.
And what is your date of birth? Earlier we went over your rights to arraignment. Any questions about your rights to arraignment that I wasn't able to answer?
No, I don't have any questions, but I would like to speak with the judge if possible.
You'll get it in a moment. So, Your Honor, I've gone over the charges, the maximum penalties, any mandatory minimum penalties. Would acknowledge to the complaint, waive formal reading, ask him to plea of not guilty. And Mr. Evans will need to screen if you would like assistance from the public defender on these new cases.
Plea of not guilty will enter. I do find probable cause to, or let me just run through them. On the case ending in 319 is a review. Case ending in 215, probable cause was previously found on November 21st, 23. In the case ending in
I didn't take part in.
just a minute. 5525 is a review. The case ending in 898, probable cause was previously found on April 2nd, 24. The case ending in 191, probable cause was previously found on January 2nd, 24. And in the case ending in 552, probable cause was previously found on May 19th, yesterday. What is the city's recommendation regarding release?
The city is requesting bail or bond amount of 500 on each of the 6 cases. Defendant has a significant warrant fight appear history, including 1 active warrant out of Tacoma Municipal Court. City believes the defendant is a high risk of future failures to appear. And also the city is requesting the court find sufficient evidence to set bail or bond on the 2 review matters as well. City believes the defendant is a high risk of not complying with court orders and a risk of disruption of administration of justice.
Any objection, Mr. Iannotti?
No,
Yes,
Mr.
ma'am. I would like to speak. I would like to.
Just a minute. I'm going to talk to your attorney for a second. And then if you want to say something and it's okay with your attorney, I'll hear it then.
Yeah, Mr. Evans indicated that he did want to say stuff, and I told him he couldn't. He also asked me to represent information to the court. He is asking the court to release him on his personal recognizance. He wants to assure the court that he would show up in person. He said he was not aware of any of his missed court dates. But I think he also wants to address the court, and I told him not to discuss the facts of the case, and he said he understood that.
Okay. All right, Mr. Evans, what do you want to say?
Yes, ma'am. And I do acknowledge the fact that the previous failure to appear, but if you give me a chance at a personal bond this time, I want to deliver a letter to you hand to hand. I will make the court date because I want to deliver a letter with a message to you hand to hand, which also will be attention to Chief Justice Roberts of the Supreme Court. So I want to assure you that if you give me a chance this time, I assure you I will show up at court, because not only is this connected to the state charges, it's also connected to a federal things that I have going on that I don't want to discuss. But I assure you I will show up. And if you can also, I'm in a tank. I would like to represent myself, and I'm in a tank to where I'm getting mistreated. I'm on 23-hour lockdown. I'm on crutches. I have a leg injury, and it's extremely difficult and mentally strenuous, the things that they're doing to me inside of the jail. That's why I say I want to, if you give me a chance at a personal bond, I assure you I will appear with the letter in my hand for you, for your insight, as well as attention to Chief Justice Roberts so he can be alerted to what's going on. You have my word on that.
You have 17 warrants out of our court alone.
You have my word, Your Honor, that I will appear. I want to,
Sir, with all due respect, you just don't come back. You have 17 prior warrants out of our court. It is your duty to keep your address updated. I think $500 each case is very reasonable, to
I
ensure.
can't afford that at the moment. That's why I was asking for personal recognizance. If you give me a chance, I assure you I will be there because I want to prove that I'm innocent of these charges and I was at the airport on your orders on personal travel.
I have never ordered anyone to go to the airport.
No, the last set of paperwork you gave me, it said that I can appear, I can go to the airport for personal travel, and that's the only time I've been there. The only time, I assure you.
I'm imposing bail in the amount of $500 each case.
And also they have me in a tank to where if I'm representing myself, it's going to be extremely difficult. I don't have any access to the kiosk because it's broke. They have me on 23-hour lockdown. I didn't do anything. I haven't been violent or anything with anyone. They just, for some reason, I'm in a segregation tank. I don't know if it's because of my injury or what, but also it's affected my leg because I'm rehabbing my leg. And it's messing with the muscles and nerves because I need to keep my leg active and in motion. And they have me in 23-hour lockdown. I'm not even in general population. So I'm asking humbly and respectfully, could you please grant me one more chance at a PR bond, please?
And Mr. Evans, you have an active warrant right now out of Tacoma Municipal Court.
I'll resolve that as well, because when I went to court, they initially told me it was dismissed. So I guess they just put something back out. I'll resolve that as well. But if I humbly and respectfully ask that you please give me one chance to prove myself, please, because it's almost unbearable for me to represent myself and with my leg injury and the conditions they have me in and me getting mistreated in the jail as well.
Okay, I've made up my mind. I'm imposing bail in the amount of $500 each case. And I will appoint Mr. Inati while you're in custody so that you will have a way. And if you're wanting to do your own research, perhaps you and he can work out a way.
Ma'am, that's the whole point I was trying to make. Mr. Iannetti is not properly represent me. That's why I want to represent myself. That's how I got back in this situation to where I was reviewed, because before I wanted to do a fast and speedy trial, he never filed the motions. That's why I want to represent myself, and I asked for a PR bond so I can hand you a letter informing you of everything that's going on, as well as a letter that you can forward to Chief Justice Roberts to alert him what's going on. And
I'm not forwarding anything to Chief Justice Roberts.
I understand, but I have evidence that will exonerate me. And I wanted to hand that letter to you in person.
Anything you give to the court, you have to give to the city as well. I can't look at it unless the city has it as well.
I understand, but I wanted to file it and make sure that you're in position soon as I hand it to you or the courts, that they're able to go ahead on and put a seal on it so it's not exposing, because anything I send from any letters I mail out.
You have to make a whole motion to file it under seal. Sir, there's a lot. This is very complicated what you're proposing.
I understand, and I have the evidence that proves that will prove and will exonerate me, but I don't want to send everything through this jail because there's so many eyes that's gonna see it. In addition to that, the circumstances and the conditions they have me in is unfeasible. I'm in 23-hour lockdown. I'm in a cell to where there's no access to the kiosk where I can look at the law library. In addition to that, I'm in a
Mr. Inati, when would you like to set this over till?
Thursday.
All right, Mr. Evans, we'll see you back here on Thursday.
Would I be able to request a PR bond at that time, or is everything?
No, you're only entitled to one bail hearing unless there's been a change in circumstances.
What about the jail conditions they have me in? I'm in 23-hour lockdown. I didn't do anything, and I'm not even don't even have access to the law library because the kiosk is busted.
I've appointed Mr. Inati while you're in custody, and or at the very least a standby counsel You can talk to him about how you want to deal with that.
Okay, and is it okay if I represent myself?
You'll have to go through there's a form to fill out.
Can Mr. Ionetti give me that form, and can this be on record that I'm saying that I want to represent myself and that I need the forms or whatever I need to be, and I would like a fast and speedy trial as well.
Yes.
Well, you've said that the speedy trial in custody is 60 days.
I understand that, but I want it on record because last time I told Mr. Ionetti this, he never made any motions to get the process started. That's why
There is no motion to make to get it started. The clock starts ticking at arraignment.
I understand, but I would like to represent myself if
And that's fine. You can represent yourself. I mean, you can file the petition to represent yourself. I don't know whether I'll accept it.
it's gonna be extremely difficult to do that with the circumstances I'm in.
I can give you the information and go over what you need with you.
They have me in 23-hour lockdown.
Okay, thank you, Mr. Evans. We'll see you on Thursday.
That's everything for me, Your Honor. I need to get into the courtroom to do the motions.
You guys still trialing?
Yeah.
Oh, okay.
We can come back to that one. This is Mr. Evans.
Hello, Your Honor.
Your Honor, this is Sylvester Evans.
Did you get the letter I mailed in, Your Honor?
I did not.
Is the court ready?
Yeah.
Okay, I mailed the
One
letter.
second, Mr. Evans. So this is Sylvester Evans. It's 380312319, 480231898, 380655525, 380820191, 480472552, and 380549215. And I don't believe you were here, Your Honor, on Monday when Mr. Evans was arraigned. But Mr. Evans at that time indicated he wanted to represent himself, and he's also indicated that to me today. I did go over the waiver of attorney on pretrial and arraignment form with him, and explained it to him and talked about it. It sounds like when I spoke with him, because he's in custody right now, I know he wants to address his in custody status with the court, but I figured this needs to be addressed first. We discussed if he's in custody, he needs access to certain things and that unlikely he can get. So he would want an attorney on standby to assist him with that. And I said that I don't have any conflicts, so I don't have any issues doing that if that's the case. But just so the court's aware. But I know he wants to address his conditions of release, but he also wanted to represent himself.
Okay, and I believe Judge Freund did do the jail calendar on Monday. So did you say competency was raised? I didn't quite understand that piece.
Oh no, I was talking about the other person. Veronica Johnson was who I started to talk about.
Got it.
And then when Mr. Evans walked in, I just said, we'll get to that when we're done with Mr. Evans.
Got it. Thank you. Thank you for the clarification. All right. So Mr. Evans, so we have not yet done the arraignment, right?
No, it was done.
It's done. So
Monday. And the city doesn't believe there's any change in circumstances, so would object to defendant's motion
I
to
guess
release or
I
adjust
guess-
bail.
Oh, thank you, Ms. General. I guess I just for my clarity, so this was on Monday and we set it again for today for what specifically?
Pre-trial and the
Oh,
tracking reviews.
okay.
Because the court set bail or bond, we set the pre-trials pretty quickly.
Got
I would
it.
like to speak to Your Honor before we disconnect if possible, please.
All right, Mr. Evans, so it's my understanding that you do not want an attorney to assist you. Is that correct?
Like you said, if he could be on standby, I would like to represent myself because I invoked my right as a Aboriginal Native American Indian chief. That's why I asked if you got that letter. So I have certain constitutional rights that's afforded to me. In addition to that, I have a leg injury where I'm on crutches and they have me in 23-hour lockdown. I didn't do anything wrong. And I was trying to see if it's possible, based on the fact that I invoked my right as an Aboriginal Native American Indian chief, that I definitely will appear at every appearance if I could get a pre-recognizance bond. due to the circumstances. I assure you I'll show up, especially that I invoke my right as a Native American Indian chief.
And as the prosecutor stated earlier, Mr. Williams, I guess, what is the change? It doesn't sound as if you're noting any change of circumstance from when the court saw you on Monday and set bail.
I
Well,
can honestly say I don't recall defendant mentioning the Native American part on Monday, but he did discuss the other thing in quite more length than he actually even is today. So the court did have that before it. Now, as far as the other piece that he's presenting today, I state's position is that doesn't change anything and there's no proof.
I sent the proof in the letter that I mailed out.
Wasn't provided to the city. I haven't seen any proof. And I would say that's not a change in circumstances.
I mailed the letter out
Like
on
I said,
I mailed the letter out on Tuesday with the evidence and the proof invoking my rights as a Native American Indian chief. So I'll be working to get this case removed to the federal courts. I need to also file in the federal courts a notice to remove as well. And it's going to be extremely difficult for me to do that from here in prison. So that's why I was asking if I could get a PR bond. I assure you I'll show up. I'm not going to play with my rights like that as a Native American Indian chief. In addition to that, I'm in 23-hour lockdown with my crutches and it's affected my leg. I broke my tibia and fibula in 5-6 different places. And the muscles and the nerves in my leg are getting worse because I'm not able to rehab it like I'm supposed to.
and Ms. Chenmuller, seeing that I wasn't here on Monday, what is the bail currently set at?
500 cash or bond on each of the 6 cases.
And does Mr. Williams have, what is his FTA history?
He does have a substantial warrant fight history, including an active warrant out of Tacoma Municipal Court. Also, has not complied with court orders, and that he repeatedly returns to the airport. We have 4 pre-trials and 2 reviews involving those allegations, the same allegation before the court today. Has warrant fight history in pretty much every case.
What is his date of birth? I'm trying to find him on JABS.
My last name is Evans, it's not Williams. And also, there's no evidence that I was trespassing each time I was there on valid personal travel. So this case lacks evidence, which is also why I asked to have it dismissed in the letter as well.
He went into that on Monday as well.
And also, I never invoked my right as a Native American Indian chief. This time I did. So therefore, I will not miss not one court date, I assure you. Can you please?
I'm not sure what you being a Native American chief has anything to do with you coming to court.
Because I represent a sovereign state, and as a sovereign state, I have the right to have these cases heard before the United States of America, the Supreme Court of the United States of America. And in the letter, I've put the details that prove what I'm saying, and also it should prompt everything to be moved to the United States Supreme Court, especially with some of the details that I put in there regarding my circumstances and what I have going on, which I'm sure Chief Justice Roberts can verify once the process or whatever, which I'm trying to go through the process now, but it's going to be very difficult to do this from inside the jail. But as a chief of a sovereign tribe that's federally and internationally recognized, I have the right constitutionally to go to, I have immunity, and I have the right as a sovereign state to have this cases heard before the United States of America. In addition to that, I have different types of immunity that I fall under as well.
All right, Mr. Evans, so I gave you an opportunity to speak just to make sure I understood exactly what was happening in this case since I was not the judge on Monday. I have had an opportunity to review your criminal history, and I do see that you have had warrants in pretty much every case that has been filed against you that I can see in the state of Washington. So right now, I'm not hearing any change of circumstance that would give me any change in circumstance that would allow me to change the bail from $500 on each case. So that will remain as previously set on Monday. Additionally, we need to address the fact that you are requesting a waiver of right to an attorney. I will note that I don't believe that that is in your best interest. I think an attorney would be helpful to you. However, if that is what you would like to do, I want to make sure that you understand that you have 1, 2, 3, 4, and Ms. You have 4 cases that are pre-disposition, and it sounds as if you have 2 review matters, which means you've already entered into some sort of plea on those cases. But on your new cases, do you understand, Mr. Evans, that these are gross misdemeanors?
Yes, ma'am.
And you understand that with that, you could potentially serve up to 364 days in jail and or pay a fine of up to $5,000?
Yes, ma'am.
Okay, you understand that you do have a right to have an attorney, have a lawyer represent you in all stages of these proceedings. And if you cannot afford a lawyer, that you have the right to request a public defender,
Yes, Your Honor.
and that a public defender, if you qualify, will be appointed to represent you,
Yes, Your Honor.
and that you may be at a disadvantage if you proceed without a lawyer.
Yes, Your Honor, as I previously
Okay,
stated.
Mr. Evans, I heard everything that you had to say. I just need to make sure that you understand the rights and that you understand that you'll be required to follow all the laws of evidence and court rules which apply to this case. Do you
Yes, Your Honor.
understand that? And that these laws and rules can be technical and complex, and that you may not fully understand them without a lawyer.
Yes, Your Honor.
Okay, and that you realize that by proceeding as your own lawyer, if you do not represent yourself in a competent manner, that you will not be able to obtain a reversal of a conviction on the grounds that you received inadequate representation.
Yes, Your Honor.
And are you aware of the risks and disadvantages of proceeding without a lawyer?
Yes, Your Honor.
And knowing that you still choose to represent yourself, knowing the risks, you freely waive your right to be represented by an attorney.
Yes, Your Honor.
So you are waiving your right to be represented by an attorney.
Yes, Your Honor.
All right.
And also, would you be able to look into a oral motion to dismiss due to lack of evidence at this hearing?
You would have to do that, Mr. Evans. You are acting on your behalf as an attorney. So that is a motion that would need to come from you and or your attorney.
I actually mailed in a letter. I was trying to see if the courts received that letter because that was in the letter that I mailed.
Okay, we do not have that letter at this time. So we're going to set this matter for another pretrial hearing.
Could you set it for sometime next week when you guys get the letter so you can understand everything I'm saying?
I believe we will have to set it in due course in regards to the court's availability.
Yes, Your Honor.
May I inquire if a copy of that was sent to the city?
I mailed it off to the clerk's office, and also, Your Honor, could you please put on note that I requested that that letter get sealed due to the protection of innocent life, not only mine, but others that's at stake due to the information I revealed about me being a Native American Indian chief and the evidence that I've revealed in it. That could you please put on note that I asked that it be sealed immediately?
And again, Mr. Evans, those sort of things need to be done in writing to the court. Mr.
I
Iona, do
did.
you have any concerns about competency?
I and I do, but I'm hoping that if the court sets a hearing next week, I think either on Tuesday or Wednesday, perhaps that letter will have come in and it might answer.
Okay, so for right now, I did sign the waiver of attorney, but I am going to allow counsel to remain on standby. Let me see when's the next time we can. Wednesday, May 29th.
And also, Yara, I would like also to put on note that I mailed the letter off on a blank piece of paper and I numbered it. If it's kind of difficult to read, you might have to put something on each line because due to the circumstances, that's why I had to mail the letter off. I mailed the letter off. Because I was in a tank to where I didn't have access to anything. They had me in a restrictive tank while I'm on 23-hour lockdown. And I have no access to the law library or nothing.
All right, so we are setting these matters for May 29th at 11 a.m., all matters. If there's nothing else to address, this concludes this matter.
Just want to note for the record that the city is going to object to the motions being heard if we don't receive copies.
Did you hear that, Mr. Evans?
They're gonna, no, ma'am, could you repeat it, please?
The city has stated, since you are acting as your own attorney, that if they do not receive the information that you've provided to the court, that they will be objecting. It is a responsibility of you or your attorney to provide any information to the court and to the prosecutor.
All I can do is mail the letter off. I mailed it off. I don't know if the guards kept it or if it gets lost in the mail. I don't know. I can remail the letter or I can rewrite it and remail it off. But I mailed the letter off. I definitely sent it off, and I have the guard that picked it up. I have documented the guard that picked the letter up. So I definitely mailed it off, and it should be on camera that I handed the letter to the guard.
All
The
right, well,
city's entitled to an opportunity to respond. We would need it at the very latest by Monday. I mean, if we're setting it for Wednesday.
I mailed the letter off Tuesday. So it may get there today or tomorrow. Because it shouldn't take no more than 1 or 2 days for it to get right there to CTAC court. I mailed it to the 4800 188th Street, and I put on there to the clerk. I attentioned it to the clerk, so that letter shouldn't take that long. If it doesn't come to you guys, that means it got lost in the mail or something like that, and I would have to rewrite it. I do have a rough draft of it. So I will be able to read it out to you verbatim Wednesday if you like, if you haven't received the letter by Wednesday. I did keep a rough draft of the letter, so I could read it out to you verbatim. Or if you don't mind, if you could give me a second, I can go and get the rough draft out of my cell right now and read it to you.
no, we are not ready to address that today. So we will
Okay.
Address these matters again on Wednesday, May 29th. All right, so this concludes this matter. Bail, as I stated, will remain as previously set, as well as all previous conditions of release.
Thank you. Then we have to put the bail amounts in.
Yes, that's what I am
Thank you.
doing. And it's 500 each case, right, Ms. Chenweller?
Yes.
Okay, thank you.
Could I get a copy of the paperwork, please?
You will receive a copy of the paperwork. All right, this concludes this matter. Have a good day, Mr. Evans.
Same here. God bless.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.